Hi, I'm attorney Richard Craig Krause, and I'd like to welcome you to our firm. In a few minutes, I'm going to ask that you watch a series of videos that introduces you to our firm, what we do, and how we go about doing it. It's a pleasure to have you here. Thank you. Welcome. This video introduces you to the philosophy of our office. We respect you as a person, and we genuinely appreciate the opportunity to speak and meet with you today. This is true whether you hire us ultimately to be your attorneys or not. You are the reason we practice law. So even if you don't hire us, you are always welcome to call us later and to talk to us about new issues or concerns that develop in your life. We respect you, and we represent real people with real needs, with real problems. In other words, you're not going to be a number, you're not going to be a case study, and you're not going to turn into either of them. Life is far too precious, its experience is too rich to allow that to happen. So, regardless of the pressures or demands that confront you, we recognize that you are special, unique. And since you're here with us now, we acknowledge that you want us to consider your matter as thoroughly as possible and as responsible as we possibly can. So, now assuming that we're able to help and that you want us to, from the onset, we will build our relationship on trust, honesty, mutual respect, and integrity. We want what's best for you. That's the primary reason why people become our clients and why they refer their friends and family to us. Also, you'll always have a right to make your own decisions. We know that you want to make your own decisions, and we respect that. Indeed, you have the exclusive right to do that. And assuming you engage us, that right will continue. Of course, throughout, we will always remain available to answer your questions, and we will provide you with sound counsel and advice. We'll talk to you as I would want to be talked to if I was the client. I want to tell you what I would want to know if I was the client. Because fully informed people make decisions that are better suited to their personal needs and objectives. We will always acknowledge and respect the fact that you may have to take other important personal things or relationships into account. For instance, your personal financial considerations, personal medical or psychological needs, morality and faith, family influences, friends, and professional or business relations may come into play. And obviously, these are things you know best, and so we will defer to your judgment when you base it on those regards. The only exception to that is we won't be party to any irrational decisions or acts, violations of the law, or the rules involved with your matter. That is the way that we would want to be treated. That is the way that we would want to be understood if we were the client. And it's the way that we would want to proceed from the onset to the end. It's respectful. The other thing is just call us. As always, if you have any questions or comments, just call us whenever you're ready. Don't be shy. Don't be embarrassed. Always just pick up the phone or come by the office. If we're already occupied, we'll just call you back. We return your calls. Communication is the key to every relationship, whether it's in the law or outside of the law. And, of course, our relationship with you is no exception. Once engaged, we figuratively enter into a partnership with you, and it's a partnership of shared interests. It's one in which you want us to use our best efforts for your benefit and we will do exactly that. Our commitment is simple. If you engage us, every person in our office will strive to do their level best for you. And we always work from the best possible results under the circumstances that present. This is critical to your understanding of the problem resolution process because every problem exists in a dynamic, ever-changing, and ever-evolving environment. This is particularly true when other parties are involved, and especially when the other party's interests may not only differ from yours, but where they may be antagonistic to yours. Changing attitudes, priorities, needs, and perspectives also contribute to the dynamics of the environment within which your challenge exists. Even if you don't engage us to act as your attorneys, we still want the best for you. And please always stay fully informed about the specifics of your matter and pay attention to the political and economic factors that influence the environment in which your challenge exists. To become a client, you must agree and sign our written engagement agreement. At this time, you are either presenting your matter to us so that we can consider whether we can help you, or you're going through an initial tax exam. To actually become a client of this firm, you first have to agree to the terms and the provisions of our written engagement agreement, and then you and we have to sign it. Engagement agreements are tailored specifically to your unique matter. They set forth the scope of our work, your financial responsibilities, including details about the payments that you have to make to us, and other issues critical to our attorney-client relationship that would then exist between us. We become your attorneys and are responsible to initiate representation of you only after you and we sign the engagement agreement and only after you satisfy the payment requirements. You're signing an IRS or a state of Michigan or another state power of attorney or are reviewing the facts of a matter does not mean that you've become a client and does not obligate us in any way other than to simply review your facts. At this point in our work together, we are either considering and evaluating the matter that you've brought to us, or you're in a tax exam. In either case, at the conclusion of our work through that first step, we would then state to you what our fee would be and how we would intend to proceed. In order for us to become your lawyers, you would have to, and we would have to sign a written engagement agreement, and that engagement agreement would reflect the specifics of the responsibilities and the issues that we would address for you, and the financial requirements that you would have to meet with us. So, from this point forward, thank you for coming in. Thank you for having us review what it is that's a certain challenge in your life. And thank you for entrusting this matter to us. We look forward to a long and positive, successful relationship. Thanks again. So, let's get started with the initial steps and let's work together. Thanks for your time. Hello, I'm attorney Richard Craig Krause, and this is a client video intro to our tax return preparation service and generally to our office. You know, we are a full service office, and that means that we work in the tax courts, other courts, and within the IRS and state tax administrative levels. Yes, we also prepare tax returns from time to time too. And as tax controversy attorneys, we've been successfully representing taxpayers with serious if not life-threatening, tax crises for more than 34 consecutive years. We represent individuals from all walks of life, families, businesses, not-for-profit organizations, and trusts. Now, you may not need all the resources that our office can provide, or for that matter, all of our experience and talent. But I am certain that what we are and everything that we bring with us will work to your advantage, even in ways that are not now immediately discernible to you. For instance, and make no mistake about it, our litigation success spurs early stage resolution. Now, as we work for you, we may have to ask you about and address details that relate to personal matters and sensitive financial details. Of course, we value your privacy and we always hold it in high regard. But there are times that we have to ask those things. For example, we'll ask that when we prepare tax returns for you or for your business. We'll ask that, secondly, when we critique returns or financial statements that were previously prepared by you or for you, or filed by you or for you. 3, if we need to effect changes to previously filed returns, we need to get into details and we'll ask you about them. 4, if we represent you in an audit, we need to be prepared. And 5, if we draft other financial disclosures for you, we're going to have to ask you about private financial situations and matters. Now, if you come to us as a consequence of having an audit that was botched, we're going to dig in and we're going to get into the facts that other people didn't either attend to or plain old missed. That's also true if we're filing offers in compromise for you and or looking at some means to try to shunt liability. Now, our office staff includes our certified public accountant and accountants, as well as bookkeepers and financial assistants. And they'll provide you with the industry accepted resource and service that you would expect, and more importantly, that we would expect if we were the clients here. We also use our own standard operating procedures. And these procedures are the developed results of 34 years of practice in this industry and environment. Trust them. They've proven their worth and they maximize results. And though our approach may be a new, if not a different experience for some of you, don't worry. Many of our clients have told us how different our methods and procedures are when it's compared to what it is that their previous accountants, lawyers, financial counselors, etc. may have used, or, if you will, didn't even use. But they all came back to us later and thanked us for doing what it is that we do as a matter of office procedure. The key is that we're dedicated to you, and the things that we bring into play are meant to accomplish and maximize what is important to you. And we do this because we want to get to the root of all the material issues that are involved in your matter as quickly as possible. And you'll ultimately understand the full scope of what it is that's involved and what we need to do to maximize the resolution for you. All of this stuff that we do, that we focus on, that we dig into, blends together. And we also want to educate you so that you don't have a risk of having new and similar challenges develop in your life in the future. In other words, we want to conclude our work for you so that you can get on with your life. And, to be honest with you, we don't want a client for life. So when we work with you, we're going to be asking you to, for instance, 1, provide information to help us understand your circumstances and how things develop to that point. 2, to give us copies of all needed documents which are accessible to you. We don't want the originals, we just want the copies. 3, to respond to continuing questions which may be prompted by our review, which means that you have to remain available to us. 4, to consider documents and help us understand the information that's been gathered from sources other than you. And 5, to review, edit, correct, and ultimately accept and approve the work that we submit to you and for you. You make all the decisions, and you make them fully informed. As this process evolves, you may encounter instances where you're unsure how the things that we're asking about immediately apply to you. And if that happens, just ask us about it. We welcome the questions. We'll tell you how it applies. In the meanwhile, please keep in mind that our staff is expected to prepare tax returns, financial statements, and the like that pass scrutiny while under fire. We don't wing anything. Yes, their questions are probing, and yes, at times it may appear that they focus on esoteric issues. But everything we do, everything we ask, and everything that we investigate is completely dedicated to fully support the advocacy which we advance on your behalf. Ultimately, you will see that everything we do is dedicated to getting you a fresh start and to resolving the problems that are now confronting you. And we look forward to working for you, and thank you for giving us this opportunity. Hello, and congratulations. You've already accomplished a very important step towards resolving your tax challenges. You called, and now you are here with us for your tax exam. So it's time to get rolling. You know, we created and make the tax exam available to you so that we can provide you with a clear understanding of the nature and the extent of your tax challenge, and to help you identify and understand the different alternatives that present to you so that you can thereafter take steps in a focused and deliberate manner towards the resolution that you want. We've been providing tax exam services to people for decades. It's a very productive means of clarifying issues and discarding many inaccurate beliefs, concerns, and anxieties. History has demonstrated that the benefits that flow from your tax exam experience is well worth your time and effort. As you know, there is a flat charge for your tax exam, and still there isn't a limit on the amount of time that we devote to completing it. Our goal is to help you make good decisions, and that can only be done after you are fully apprised of the true nature and extent of your challenge. That means that we will spend the time that is necessary to understand your salient facts, and we then weave them into the law. The end result of your tax exam is to present to you alternatives that will maximize the benefits and protections that the law extends to you. The truth be known, the flat rate that we charge for your tax exam is a mere fraction of the total time and effort we commit to this process. And in part, we do this so that we can establish and demonstrate for you our credibility and commitment to you. After 35 years, we continue to make tax exams available because we know that tax challenges can seriously debilitate people. And we know that as the tax machine continues to roll year after year, that what was once difficult for somebody actually becomes extraordinarily oppressive. And your tax exam serves as a means to stop that from happening. Now, years ago, we coined the phrase tax crisis to help people understand that it is common for tax problems to challenge people financially, psychology, emotionally, and yes, even physically, to such a point that they are incapable of advancing for their own benefit. Certainly not everyone is set back in each and every such regard, and certainly not to the same degree. But I sense that you have some personal insights already along these lines because, well, you're here now. During your tax exam, we will review the history of your tax challenges as well as the circumstances that caused or contribute to them. Yes, what happened to you is important. Further, what you want to accomplish and what you can reasonably accomplish is also important to us. Yes, there are provisions in the federal law that allow us to shape your facts and the presentation that must be made so that your circumstances are as compellingly presented as possible. That's the key. That's why you're here. That's why we are tax controversy attorneys. Now, your personal circumstances, your personal challenges have very critical, unique features that must be taken into account. And if they're ignored, then you're really losing some very critical benefits that could flow directly to you. So the point is, we need your help. We need to know as much detail about your situation as you can possibly give to us. And because of that, we ask that after your initial consultation today is finished, that you sit down and create an outline of events and give it to us in the next week or so. Of course, if you have an emergency, you're going to have to move faster than that. But generally, a week is enough. As you write your outline, be sure to include anything that seems to relate. Approach your outline, approach your history in that manner, and the risk that you will inadvertently leave something out will be reduced. And we can then decide and assign weights and priorities to the information that you provide us accordingly. In the same vein, give us copies of all paperwork that you have. And even if you know it is not everything that exists or which you've received over time, we still need to have copies of the things that you still retain. And that's important because all these documents fit within the flow of things and the evolution of your problem. And we want to make sure that nothing is overlooked and nothing is missed. Now, this procedure gives us a chance to learn as much as we possibly can about you, your tax challenges, and your intentions. Today, you're going to be asked to sign documents that are referred to as powers of attorney. Now, they're unique and specific to the tax practice. Once signed, these documents give us the authority to speak with the taxman about your tax challenges, and we can then obtain your tax history and the related records. Our work in those regards is also included in your tax exam. Now, at the conclusion of your tax exam, we will report to you the alternatives that are available. We'll go over that with you too. We'll discuss this with you and we'll answer your questions at that time. Now, assuming that you have a matter that we can help with and that we can consider you as a potential client, we will then discuss what our fees will be, the required advance that you have to pay, and all other related issues. To become a client, you will have to sign, and we will have to sign, our formal written engagement agreement. For most people, what they learn during their tax exam is an eye-opening experience. In the 35 plus years that we've been actively, continuously, successfully representing taxpayers with serious tax challenges, most people have come to us with a demonstrated lack of basic knowledge of their legal rights and obligations. This is true for all the taxpayers who were represented or advised by earlier financial planners, accountants, and yes, lawyers. That's true. The fact is that people come to us because we have this very unique talent and experience. And generally, too, people don't even know how the IRS or state formulated its demands. And they have demonstrated a consistent lack of understanding about the general alternatives that may be available to them, let alone how they're going to be implemented to succeed. But the one big thing that they share commonly is that each one of them knows from their personal experience that they are continuously hounded and oppressed by the financial and emotional stress that accompanies their tax challenges. That's right. We refer to serious tax challenges as a tax crisis. And as I said before, it has emotional, financial, intellectual, and possibly even physical components to it. And this is why people can't look at it seriously on their own and can't deal with it to address it successfully on their own. Now, though you have a serious tax problem, we understand from you at this time that you're not facing any pressing deadlines or immediate threats. If you are, you have to let us know precisely what you think they are. That's key, because tax problems from time to time have to be handled as emergencies. And yes, we have what is essentially an emergency room law office, so we can respond to it. But critical dates may be imposed on you, and they must be addressed as early as we can. And that includes appeal dates, that includes requests for asking for particular type of hearings, that includes activity to avoid levies or to respond to levies that are already in place, just by way of example. So if you have received threats that somebody is going to levy you, that the tax man is going to take your money, whether it's from your wages or from your property, for instance, or that it's going to file liens against you, that may require emergency reaction and emergency work. And so that has to be addressed after it's identified, and it must be identified now. So help us in those regards. Well, thank you for listening. Essentially, what we want to accomplish with everybody that becomes a client is that we share the same objectives that you have, and we share the desire that you get your life back. And that's entirely what our practice is all about, and that's what we work on diligently every single day for you and everybody else. So thank you for entrusting your questions to us at this time, and we look forward to a long and continued relationship. Thanks again. We created and make this audit tax exam available to you so we can provide you with a clear understanding of the nature and the extent of your audit and tax challenges. We'll show you the different alternatives that present to you at the conclusion of your audit tax exam, so you'll be able to make a confident choice about how you want to reach the resolution you seek. Now, we've been providing audit tax exam services to people for more than 35 consecutive years, and we do it because it works. It clarifies issues, discards inaccurate beliefs, and eliminates unnecessary concerns and anxieties. History has proven, and we are sure that you'll agree, that your audit tax exam experience is well worth your time, effort, and money. As you know, there's a flat charge for your audit tax exam. Still, there isn't a limit on the amount of time that we devote to completing it for you. Our goal is to help you make good decisions, and that can only be done after you are fully apprised of the true nature and extent of your challenge. The end result of your audit tax exam is to present you the alternatives that will maximize the benefits and the protections that the law extends to you. The truth be known, the flat rate that we charge for your audit tax exam is a mere fraction of the total time and effort that we commit to this process. After 35 years, we continue to make audit tax exams available because we know audits and the pressures that come with them can seriously debilitate people. And we've seen how the government throws its weight around, especially when people aren't represented or when they have representation that isn't appropriately experienced or ready for the engagement. Now, we have seen how that lack of knowledge and experience is used to people's disadvantage distinctly, where additional taxes are improperly imposed, where massive penalties and interest is added, and where, quite frankly, someone doesn't even have the foggiest clue of why what it is that's happening is improper. Now, we've seen taxpayers pay tens of thousands of dollars and even more unnecessarily, if not improperly, because the law just didn't support the demand to begin with. Years ago, we coined the phrase tax crisis to help people understand that tax problems can challenge individuals financially, psychologically, emotionally, and yes, even physically, to a point where they are actually debilitated. Now, certainly not everyone is affected so severely, and not everyone is affected in the same way or in the same particular extent. But every taxpayer has the ability, based on their own experience, to sense how this type of thing can happen. And especially if you have already been affected in one of those particular component fashions. And moreover, there isn't a single taxpayer who wants to undergo a tax audit, or for that matter, to have to pay additional tax penalties or interest, or see the auditor expand the scope of an audit deeper into transactions and into relationships that weren't expected, or into additional years or other tax returns. But if you don't know what your rights are, if you don't know what limits may be applicable against an auditor and the activity that the auditor is engaging, if you don't know how to and the timing that you want to bring these rights into play, then you're going to be completely at odds and at a disadvantage in the process. The point is, we know. So, during your audit tax exam, we will review your history, the challenges and the burdens that now confront you, and the procedures and the means best to address them. And yes, what happened to you and how it happened is important. What you want to accomplish is important too. So, there are provisions in the federal law and the state law that lend themselves in such a way that allow us to shape your facts, your circumstances, to shape them within the context of your goals, so as to maximize the benefits and the protections that are available to you under the law. That's what we do. That's why we're tax controversy attorneys. In other words, your tax challenges probably have very critical features that should be taken into account when we consider your facts, and which, if they're ignored, are simply going to force you to run the risk of not enjoying the benefits and the results that actually could work to your advantage. So the point is, we need your help. We need to know as much detail about your situation as you can possibly give us. And because of that, we ask that after your consultation today, you need to sit down and create an outline of events and give that to us in the next week, or less if you have an emergency. And if you have an emergency, that will be discussed today too. In any case, as you write your outline, be sure to include anything that seems to be related. Approach your outline, your history in that manner, and the risk that you will inadvertently or unknowingly leave something out will be reduced. We can decide and assign weights to the information that you provide, and we can also help you establish the priority in regard to what needs to be provided, if you will, first, if information might not be available to you at this moment. Now, later today, to help you get started, we'll give you an outline sample that will help you organize your thoughts and efforts to bring us up to date. And you'll also have to sign documents that are referred to as tax powers of attorney. Now, once these are signed, those documents give us the authority to speak to the tax man about your tax challenges and specifically about your audit process, and to obtain your tax history and related records. Yes, all of that is included in the flat fee audit tax exam. In any case, please never forget, tax auditors are highly trained, primarily dedicated to finding two things. One, it seeks to find additional revenue for the government. It's as simple as that. And two, it seeks to identify crime. Now, because of this, it is unwise for you to represent yourself during your audit. And frankly, we don't say that idly. A clear objective, a clear perspective is necessary, and simply good intentions and best intentions are not enough to carry you through an audit. Over the years, people have routinely come to us after they or someone else handled their audit previously, only to find that the results were disastrous and completely outside of the realm of their expectation. Sure, in most of those cases, we can still help, but look how much time, energy, money, and emotion has already been consumed. Invariably, those people complained that the auditor's decisions didn't square with the facts, are extremely heavy-handed, or are outright illegal. And they look like they were shocked. And many continue to tell us that they thought that the auditor seemed to be a nice guy. Now, imagine entering that into the formula. It doesn't, does it? The truth is, auditors are highly trained in the use of the tools that are made available to them. They use those tools to pursue those two goals, which are, again, raise money for the government and identify crime. So that's the mentality. That's the predisposition. The framework within which everything you innocently, well-intendedly, make available to the auditor through your disclosures are decided within that framework. Sure, the vast majority of IRS auditors and state auditors are professional and cordial in their demeanor. But don't misinterpret that conversational approach, because beware, nothing could be further from the truth. Such subtleties are beyond what most people can comprehend in the audit environment, and so the most innocent event, the most innocent statement even with the best of intention, can be subject to being terribly misunderstood and misinterpreted by the auditor. There's that much of a disconnect between a person who's being audited when he makes the statements and the auditors who's trying to evaluate everything within the framework that I already laid out. Amongst auditors and investigators, stories abound about how taxpayers unknowingly disclosed or unwittingly provided information by not answering a question succinctly or directly, or, for instance, where someone nervously kept talking while the auditors just sat still, or where the return address on envelope sitting in open view contradicted information that's already been provided. It happens. Or where a kid or a neighbor may say something which is at odds with what the taxpayer has either been saying or trying to convince the auditor to understand. Now, even if the auditor does not directly challenge a taxpayer face-to-face or at any particular line item during the meeting, it doesn't mean that there isn't a problem. Okay, you get the idea. That's probably enough, at least for now, isn't it? Because you already sense that you need assistance, you need representation when you're in this audit experience. And you need it because you don't know what you don't know. Okay, that's a given, and that's factually accurate and experientially true. What's next? Let's complete this audit tax exam. And let's do it within that time period that I've already set up. Get your information to us within a week unless you have an emergency. And if you do, that's going to be talked out today too. And new dates for action will be set. And then we'll complete the audit tax exam, talk to you again and sit down with you again and go over the particular alternatives that are available and what we can forecast as to what it is that we think we would do if we were you. And then we can go from there. You can make your choices, and we'll also tell you what the fees are that would go along with the rest of the work that we would perform for you. And assuming that we all agree, then it's just a matter of signing the final engagement agreement paperwork and paying the necessary advance. Hello. We are tax controversy attorneys. We are deeply experienced and have extensive resources under our roof, ready to respond to, if not preempt, challenges that may confront you in your tax crisis. In a very real sense, you can consider us as a tax crisis hospital. Whatever your condition, whatever your needs, we can address and resolve them. And yes, that includes even emergency needs. Now, starting with the basics, our staff can provide you with the full scope of accounting and financial reporting services. But more importantly, with respect to more serious, more complex business or life-threatening tax crises, we have the resources needed to shape the issues and the facts so that the benefits and protections available to you under the law are maximized. And we can bring them into action in audit, during any investigation, in litigation, or when you're being crushed by the tax collection machine. So take advantage of our resources. Without them, without our talents and deep clinical problem resolution experience, without our successful track record, you subject yourself, meaning you subject your future, to the luck of the draw, which in tax environment means that you are at a clear and distinct disadvantage So trust us. Tax return preparers, accountants, certified public accountants, financial planners, enrolled agents, investment analysts, prior IRS employees, and many other professionals do. In fact, they not only refer clients and cases to us, but we represent them when they have tax challenges too. And there are 3 distinct reasons for that. First, they acknowledge our prowess in the art of advocacy, which is the skill and the manner with which facts, circumstances, events, and the law are compellingly interrelated and presented to maximize the protections and the benefits available to you. It features compelling, riveting, writing and speaking skills, technical training in contentious and stress-ridden environments. And it also features intuition that has evolved from our 35 consecutive years of clinical hands-on experience, successfully resolving or avoiding tens of thousands of tax crises for our clients. Now understand, in the government, decisions are made by people who are under pressure, who are overworked, who may not accurately understand your industry or your business, and who may in fact have been trained to be predisposed against you, but who nonetheless will wield their substantial discretionary power in a way that will have a huge impact on your life. So use us to your advantage. The point is, if you or your representative doesn't know what should be known, you are at substantial risk of achieving nothing more than bad results. So keep in mind, as tax controversy attorneys, we are licensed to practice and represent taxpayers in the tax court systems, including the tax courts themselves, the respective state courts, federal district courts, federal courts of appeals, and the administrative courts and administrative levels of the IRS. It means we have the power to seek assistance, outside review, and redress of improper IRS actions and decisions. Now, your problem may not require those additional resources. Still, you can't ignore the reality that having the power of our authority at your disposal adds extra credibility and weight to your position, even if only subtly. And of course, if you are in an industry noted for sharp practices, or you are perceived as improperly manipulating circumstances, or in the event that you've made disclosures that are questionable or less than being honest, if you will, or even if you're at risk of such things, you must contact us and use our resources. And that's particularly true if you've already been scrutinized or you've been accused of having engaged in some intentional illegal activity, because you need to know what your constitutional and trial rights are at the earliest possible time. Now, in the beginning of this video, I said that the proper resolution of your tax crisis can't be determined by merely punching the keys on a calculator. And that's true now more than ever. And now you know why. You are important to us. Thank you for listening. Hello, I'm tax controversy attorney Richard Craig Krause, and I'm going to talk to you today for a few minutes about IRS filing notices of federal tax lien
against you, your business, or your family. Now, these things are punishing, they're damaging, they're hurtful. And yet, at the same time, I'm here to talk to you about changes in the law that can actually provide you with an opportunity not just to get out from underneath the burden, but literally to change history, to go back in time and take action that can remove that filed notice of federal tax lien from history so that nobody knows about it from this day forward. Now, do you know that the IRS, the collection machine, files nearly 1 million new IRS notices of federal tax liens against people and businesses each year? That means that each year, all those newly filed IRS liens get added to the tens of millions of other liens that were previously filed by the IRS. Now, imagine the level of disruption those things, that total action, causes across our nation. The truth is, when an IRS lien gets filed, people get hit hard. And when millions of liens are filed each and every year, millions of people, their families and their businesses are they're reduced to live day to day. Of course, if this would happen to you, what happens across the nation probably doesn't matter that much anymore. Instead, when it happens to you, it instantly becomes personal because it forces itself into your life, into your family and business life. There's no doubt about it. And to make matters worse, when the IRS files its lien against you, you feel like it's rubbing your nose into your problem. You don't have to be told that you're already delinquent. It actually hits you in the raw nerve, and it parades your inability to pay what the IRS demands right in front of you again. But worse still, it launches your delinquency into the public record. It announces to the world that the government has a legal right to your property. It announces that you're in default, that you're considered a bad risk, and that you are not credit worthy. Now, to say that that will wreak havoc on your life, your emotions, your family, and your finances is an understatement. At the very least, filed IRS liens will devastate your credit rating, and things can get worse. And I have to talk to you about the damage that these things cause, just for a moment. For instance, filed notice of IRS liens can keep you from getting a new job or cause you to be fired. They can keep you from receiving or maintaining a professional license, for instance, a financial advisory service. It can keep you from obtaining insurance or performance bonds. And it can force you to have to pay higher interest rates when you borrow money or you seek a loan. And that assumes that you're actually going to be offered the opportunity to borrow money when you seek a loan, because many conventional lenders automatically will shut you out. They can also prevent you from selling real estate, and even if you can sell real estate, those liens will divert proceeds from the property sales away from expenses which you feel are a priority. In other words, you're not going to get your money, and you're not even going to have the use of that money for purposes that would be better spent. Now, these liens, once filed, can also prevent you from buying business equipment or expanding, and they can actually keep you from buying a home, because most mortgage lenders won't have anything to do with you until that lien gets corrected. Now, the destruction that those liens can cause actually continue after you've paid your IRS delinquency in full, or the statute of limitations on collection has already expired, or when you successfully complete a bankruptcy, or after you've fully paid an offer and compromise settlement that you reached with the IRS. Now contemplate that for a minute. It's crazy, but the truth is the negative impact that these liens can cause will continue even after the IRS files a release of lien, because the release of lien does not remove the notice that the IRS has publicly filed from the public record. In other words, once filed, it serves just like a billboard that announces your purported irresponsibility to the rest of the world. The answer is that lien needs to be removed from your history. It's as simple as that. Removed from the public record. And recent law changes provide an opportunity to accomplish precisely that. And these changes can provide you with a genuine opportunity to reestablish your credit and to actually improve your credit rating. They can give you a fresh start to access new credit and new credit lines and to get better rates. Yes, these changes can actually help to reestablish your financial stability, and they can help you build, ultimately, towards a retirement that probably won't be available to you if the lien remains. And once removed, the IRS notice of tax lien will no longer adversely influence how people, how banks, and how the rest of the world perceives you. So, for a minute here, I want to compare a few of these differences. The differences between allowing those liens to remain of record even after they're supposedly, quote, released, and not being there at all, because you're going to be treated differently in both of those circumstances. There's no doubt about it. And consider, for example, how much you'd have to pay additional if you borrow money for a 30-year loan at 8% as compared to a 4% interest rate on $100,000. Now, if you made all your payments on time, you'll pay $264,155 on an 8% mortgage, but only $171,869 for a 4% mortgage over that same time. You'll save more than $92,000. $92,000. And that's money that would be available to you over that time for other expenses. It could be considered completely discretionary income, or it could be contributed to a retirement plan for your own benefit. Now consider the positive feelings that will flow to you under the one circumstance versus the other. And that's part of this problem. It's not simply financial. But let's look at another financial situation. Let's look at a person who's trying to buy a car. And with that lien in place, many lenders will not loan any money whatsoever, even if you're willing to pay 15% on that loan. But let's assume that you are offered that opportunity and you're willing to pay 15%. You're going to pay thousands of dollars more when you compare that loan against a loan that may only charge you, in current market conditions, 1% or 1.5%. And even then, because of your financial limitations, you're probably going to be reduced to purchasing an older car, and one which is obviously not new and not under the same warranties as original manufactured vehicles. So you see how this has a tendency to not just snowball, but it affects so many components of your personal, your family, and your business activity. There's just no doubt about it. The point is, credit ratings are used to establish insurance premium prices, housing costs, equity loans, transportation costs, business loan terms, just to name a few. So it's time. Please check your credit report. Go online. Check your real property title history. If you find that there's still an IRS lien associated under your name, take the next step. Call us. You know that the IRS will not take any action on its own to clear your record, even after it's been paid by you in full. But we can. We can help you exercise your rights and initiate the challenge that's necessary to get that lien removed from history. And we know what needs to be done. We can move this away from the smear that consistently appears in that public record. Correct history. Regain your future. This is what we do. And thanks for listening and watching.